to do with anything that I would do. But I'm disclosing that to you. If you want another judge to sign off, I can have another judge sign off on it.
Yeah, that won't be necessary.
It won't be necessary? All right. Thank you, sir. And it's signed. Thanks, folks, for working it out.
Judge, I hope she wasn't leaving because she was embarrassed of me, but
well, we'll talk. I think actually I embarrassed her, but that's the way we roll. So okay, all right, thank you. All right. She's like, look at she's blushing. And I have the Norman. Court has now the case of the people, or not the people, of Stanford versus Norman. All right, state your name, sir.
Bill Stanford.
And Miss Norman, can you hear us?
Yes, good morning, Susie Norman.
Thank you. All right, this is a time and date for the court's decision on this case. I've listened to the testimony from the parties and am prepared at this time to issue the court's decision. The first finding that I'm going to make in the case is, and I'm doing so because I think the security deposit, well, there are different amounts that are claimed. The leasing agreement clearly indicates that $3,500 was paid as a security deposit. That security deposit, so that the record is also clear, was not held as it should have been pursuant to statute. So there's nothing presented to the court that would indicate that this is an amount held in a separate account for this tenant. Therefore, that in this court's mind, that leads the court to the default position of looking at the leasing agreement, and it was the $3,500. The court will find that was paid or should have been attributed to the security deposit. There are then claims by the landlord, and without getting into whether or not the landlord has properly complied with the Security Deposit Act, I will come to that a little bit later. But there is a claim for damages Holloway, which account for $1,090. In looking at that, the court does not, there is no justification that the court sees for the damages that are listed here to be applied to the security deposit, number one, because they are not really damages. Saying that certain things had to be carried away. And the court would find that the plaintiff has not sustained their burden as it regards that claim of the $1,090. The cost for blinds, the cost of the blinds in this case, there weren't really adequate proof per se of all of these blinds having to be replaced in the fashion that they were replaced. In fact, it only looks like there is 8. There's also this $250 labor charge, and it's unclear to the court because none of the people who did this labor, with the exception of the plaintiff in this case has said in some ways that he did some of the labor. But I don't have any of those individuals there. I don't have a receipt or anything along those lines for what was paid to them. And so I will allow the cost, although it may be a bit high, I'll allow the cost of the blinds plus obviously something had to be done, but I'm not allowing the $250 in labor. I'm only going to allow $150 in labor. So that's, you're going to need to keep track of these numbers for me. So that is 200 instead of 361.13. It is going to be 261.13 that Miss Norman might owe for the replacement of the blinds. The window glaze removal, while I think that's a bit high, I will allow the $100 for the window glaze removal. I will, and I'm not going to have a dispute. I did see some screen damage to the premises, so I would allow that $100 for that. The replacement of the doors and installation is a huge problem because the cost that's attributed for these is $1,775 plus materials. So the doors themselves, the landlord has estimated at $211.47. But then the labor charge seems high and ridiculously high, quite frankly, at $1,775. Because it's so high, and I can't even figure out what it specifically is for, I'm going to disallow the entirety of that, with the exception of the material costs, which seems reasonable. Cost of the new locks to the premises, that also is a problem because I'm not sure again where this $100 an hour is coming from. I don't and didn't have, as I saw, a receipt for those locks, and I'm not sure that the locks needed to be changed or they could have been rekeyed for a lot less than these cost of new locks. I will, however, give the defendant $200, which I think is generous, giving some benefit, give the plaintiff that, with some benefit to giving him some benefit that the locks even needed to be changed. There is a water and sewer balance. Again, I didn't get anything on this, and I don't know that that was due. It just says that. And I'm not going to allow it. Cost of the fridge drawer, I don't, and I was not presented a receipt for that. And so I'm not going to allow that. There is this writing on the walls, chalkboard, furniture, solvents and paint that he's charged $875 for. I see some of the pictures. Do not, again, I'm having problems with these labor charges that the defendant is, or that the plaintiff is putting in here. And so I'm only allowing on that, I'll allow $500 for that. I think, again, that may be a bit of a high figure. But obviously there is some cleanup or some damages in that regard. Um,